All right, good morning. It's 9 o'clock and it's time for jail car. Okay, we do have a quorum. And let's seat Representative Broda for Representative Hatch and Representative Hacken Phillips for Representative Schmidt. Okay, and Senator Chandler. Okay, our senators are here. Okay, minutes.
No additions or changes.
Okay, do we have a motion on the minutes of the last meeting?
So moved.
Any discussion? Those in favor?
Aye.
Opposed? All right.
Madam Chair,
Yes, sir.
who made the motion on that? Okay.
Se- Representative Broda, I believe. All right, we have one item to be postponed. That's the physician assistants, since the Board of Medicine will be meeting on September 5th. And they'll be able to have it for our next meeting. Do we have a motion to do so?
To postpone the Board of Medicine to our next meeting.
Second.
Okay, any discussion? Those in favor?
Aye.
Opposed? All right. So now we're into the Board of Mental Health Practice. Good morning, OPLC.
Madam Chair, I believe
Good
we
morning,
skipped the consent
Representative.
agenda.
Sorry?
I'm sorry, I believe
On consent item. All right. Do we have a motion on the consent agenda?
I move to accept the consent agenda.
Second.
Second. All right. Any discussion? All right, seeing none. Those in favor?
Aye.
Opposed? All right, Senator Gray, you're in for Senator Lang. Okay, so then the next item is the Board of Mental Health Practice. So,
So this is 2022-232 on license and registration requirements, applications, and fees. The board did file an amended conditional approval. The heading says revised conditional approval, but this is actually an amended. It's not a revised, as it's the only second one that they submitted. The first comment on page 6, which is also made on subsequent pages 7, 12, 18, 19, 20, 21, and 37 of the amended conditional approval text has to do with the PLC 1002 and 300 rules. Once again, this is just an informational note to the committee to keep this on your radar, as well as to track which boards are actually citing to these rules. So I won't get into that comment too in depth. The only other comment I had was on page 29, which is then repeated on page 36. It's an unclear comment because it's unclear of whether the board can request an applicant's social security number on an application to take a prerequisite examination to be a social worker or a marriage and family therapist. RSA 161B:11 authorizes the collection of social security numbers for any applicant for a professional license. However, this is not for a license. This is just to take the exam. So it seems unclear of whether or not they actually have the statutory authority to do that.
Good morning. Thank you for holding the special session. I want to apologize for us missing the last meeting. Douglas Osterhout, General Counsel for the LPLC. With me is Attorney Rakia Medley, and she is the Chief Legal Counsel for the board side of OPLC. So it's interesting. I looked into the question based on Attorney Ricard's comment, and there was a section. Let me grab my note real quick. I identified two of the social security number issues. One of them is an NHP 30603, That relates to marriage and family therapists. I don't think we need that number, so suggest we just strike that piece from the rule.
Okay, glad to have that.
The social workers 30403 is a little bit more complicated. So the way that works, and this is done nationally, is that individuals come to the state for recognition with the Association of Social Worker Boards, the ASWB. Once they meet the prerequisites, the state then gives them approval, and the state has to register those individuals with the ASWB, and that allows them to sign up for the examination. And that's just the way it's done. I think it's done in something like 80% of the states, as I was told. There is no way for applicants for social workers to register with the ASWB independently without going through the state. So the state creates the account, then the individual goes and signs up for the test, and the information the state provides is what the ASWB uses to identify and make sure it's the same person. I did print out the language of 161B11. It says essentially for social security numbers of any applicant for a professional license, commercial driver's license, occupational license, or marriage license. So it is limited to those uses to request social security numbers. Now the question I think is for the GELCAR, I suppose, how far do we want to extend 161B11? And does this, as a piece of the application for professional licensure, fall under that purview? And I will point out that in 2014, this is the current rule. There was a form approved by GELCAR, and the social security number is on that form.
I see. Any comments from the committee? Questions? So this test is required to become a social worker,
Correct. Correct.
but the social security number is being used by the test vendor or the professional association as an identifier, despite all protestations to the contrary. And the test vendor is requiring.
Correct.
I guess I'm okay with it. I mean, I think it's
Okay.
part of sort of part of the process, it seems to me, of getting licensed.
And it's not asked for anywhere else in the process, is that correct?
I'm sorry, could you repeat the question?
Are you asking for the social security number anywhere else in the process?
At initial application.
Isn't this the initial application?
Well, that's why it's interesting, because this is approval that the board has to give or the state has to give in order to take the examination, and passing the examination is part of the initial application process. So the nexus is there. It is tied to licensure in this state, but it's not crystal clear.
All right. Would you care to make a motion, Representative Lynn?
Yeah, I guess I would move to approve.
May I ask a question?
Please, please.
Thank you. With regard to the issue of application and fees and licensing fees that was to which the attorney referred, about 6 weeks ago, we heard that there was work in progress to rectify that. Where does that stand now?
We are actually taking a very hard look at licensing fees right now. We met last week and we're implementing, or 2 weeks ago. Time is meaningless. And we're taking a hard look at fees right now.
And when do you expect to have?
I couldn't give you an affirmative answer right now, or a definitive answer.
Thank you.
Any other questions, comments? Representative Broda.
So in the request to put this, I'd like the explanation about, it says the applicant's social security number for the purpose of child support enforcement pursuant to RSA 161:B. So I'm trying to rectify that statement in relationship to the application.
So I think this is a holdover statute from when the board was with HHS, and essentially the authority there was to, in individuals, or in cases where individuals weren't paying child support, it was a mechanism the state could essentially revoke licensure until back child support was paid. They can do the same thing with driver's license. I'm not familiar with that statute, but that's where it stems from.
Yes, they threatened to take away your license so you can't work until you pay your child support. It doesn't appear to be logical, but I believe it's something federal.
Is it a federal requirement? Is that where it stems from?
I don't know where it originated from.
I'm pretty sure it's a federal requirement based on paying child support.
I think you're right. I'm pretty sure you're right.
And I have a follow-up question. So is this consistent with other applications that,
Yes, nearly all the professional licenses ask for a social security number and they mention this statute, or at least that it's for purposes of child support.
okay, thank you.
Director Morrell?
I don't think we have a second yet.
We don't. Is
I'm
there
sorry,
one?
what was the motion?
To approve the rule as amended. the
I'll,
corrective
s-
action.
I'll second.
Okay. Any further discussion? Okay, those in favor?
Aye.
Opposed?
No.
All right, thank you. Senator Gray votes no.
Okay, professional engineers, I will take the two together. This is 2023-44 and 2023-116. 44 is on ethical standards and license surrender, and 116 is on continued status. They both have the same issue. There are some comments around the fees, but I won't spend any time on that. The main issue is that the rules have been expired since January of 2022. You do have in your packet a memo from Tina Kelly stating that for the first one, for the ethical standards and license surrender, she states that they have not enforced the statute, or they have not enforced the rules, and that no disciplinary action has been taken against professional engineers for violations to the expired Engineer 501 ethical standards. She didn't submit that. She didn't submit a statement like that for the next one for 116. In both of these, Tina has submitted revised conditional approval requests. They should be amended conditional approval requests. That's just an FYI for your motion. So both of them have amended conditional approval requests associated with them. And that is the only issue, is that expiration from last year.
Yes.
Good morning, Douglas Osterhout. For the record, OPLC General Counsel. With me is Attorney Rakia Medley, counsel for OPLC as well. So I did look into this. There has been no discipline from that board since 2019. Additionally, I checked, there are statutory references, particularly for ENG 500. There is a RSA 310-A:22, which essentially functions as a charging statute. So the board wasn't entirely without a mechanism by which to hold licensees accountable.
But what about the license renewals and the other bit?
The license renewals, I checked with the head of licensing yesterday. As far as I know, there are no denials. So under the process too, right, 541A, 29, and 29A, we have an obligation to provide applicants with an opportunity to cure any defective applications. And we also, if there are particular issues, they would have conversations with the board in person, sort of show cause hearings. As far as I know, to the best of my knowledge, there were no denials during that time period.
What about the fee? Is it statutory or only in rule?
I'm sorry, could you repeat the question?
The licensing fee for continued status?
The 1002 is the same issue.
No. But
Maybe I'm not understanding the
my
question.
question
Sure.
is, while this rule was expired and you're renewing licenses without denials, are you collecting the fee? And if so, is that fee defined in statute or only in the expired rule?
That's a really interesting question that I do not have the answer for right now. I will have to check on that for you.
Okay,
Does
Any
staff have
questions?
an answer to the question?
Sorry, I'm going to look at the statute right now.
thank you. I believe it's at the discretion of the board, if I remember the engineers.
Madam Chair,
Yes.
I have a quick question. Do these rules at all conflict with the upcoming changes that were made in House Bill 655 for disciplinary action?
I would have to do a more thorough reading of these particular rules. I do think there's something in the soil rules that are on our radar where, as of October 3rd, the statute that it's referencing no longer will exist. So I'm not aware of that situation here. I would have to do a closer reading and compare it to the language at FCB 107. Nothing caught my attention when I was going through this, but I can't say for sure yes or no. But I did identify something somewhere else.
Follow up?
So can we have that answer? May we have that answer? You can email it to us, or so that we just don't cause ourselves.
Yes.
Thank you.
Yes.
There is 310A21 does allow the board to issue renewals, and it does talk about renewal fee in there.
But it's not
Right.
defined.
No, it says the board shall charge a 20% reinstatement fee, but it does not state how much that fee is.
Okay, well, this continued status is just a normal renewal, not a reinstatement, so.
Correct.
It is also, the continued status is also for renewals. It is cited as authority in their appendix. So this is part of the authority that they're using for these rules.
Yes, I understand.
And they do have, I'll have to double check the bill, whether or not that was changed, but there is 310A7 that does grant the board authority to assess the fees.
Director Morrow,
There have been instances, I know, with the boards under OPLC where they have not collected fees during the period of expiration. But I don't know what the circumstances are here.
okay, then I'd like to make a motion that we approve the rule with the information that we asked about the authority, and also with a comment or assurance that the fees set in the rule have not been collected while the rule was expired. Is there a second?
I'll second.
Okay. Any questions, comments? Senator Gray?
My problem is with the fees and the collection of the fees during the expiration period. The way you stated the rule, don't know that I'm comfortable with. Turn my mic on. I don't know if I'm comfortable with that part of it right now. Okay.
The OPLC has refunded
let me-
fees in the past, but go on.
And that's where I would like to get in the motion is that if there is not statutory approval that they refund the fees, any fees collected,
Sure.
stating in that way makes it clearer for me that they have an obligation, A, to find out, and B, if they were, without, so, if you will modify that, then I can support that.
I would agree. The intent is that if there is not explicit statutory authority for the fee, then the expired rule can't be used to collect it. So, yes, we'll modify the
Okay.
amendment to say so.
Just
Can I
like,
just make a comment about that? I guess the thing that that troubles me about this is
who's complaining? In other words, if I certainly could agree that if somebody who got their, who renewed their license was charged a fee and there was no authority, and that person said, wait a minute, I want my money back. Absolutely, I have no problem with that. But I am a little troubled with the idea that we are now gonna sort of, without a complaint from somebody, take it upon ourselves to say, no, if you collected the fees. I mean, I don't think that there's some suggestion that anybody was acting in bad faith. And so if they collected the fees and they shouldn't have, and nobody's complaining, I'm not
Well,
troubled by that.
Thank you, Representative Lynn. I'm complaining because we have a very clear statutory statement that an expired rule cannot be enforced. If the amount of the fee is specified only in the rule, then they have no authority to charge that amount rather than $1 or $10,000. And that's why if the board is so careless as to let their rules expire, we need to shake them up a bit and say, you don't have the authority to charge these fees, even though you did the work.
Well,
if I-
except my only problem with that is that, so now what we're gonna do is we're gonna give the board more work to do to refund, to go about finding out who they charge fees to and refund the fees. Presumably, that's not gonna help the issue of their keeping up with the, not letting rules expire. And I agree with you completely. They shouldn't have let the rules expire. I don't have a problem with that, but.
Representative Grota?
I understand what you're both saying, but at the same time, a rule is a rule, and you can't give authority. I mean, people cannot just unilaterally decide what to do if the rule has been expired. So I just think if the rule's expired and it can't be enforced, then I agree that they should refund the money. And unfortunately, if it is a lot of work, it is a lot of work, but it's also a reminder that these rules count for something. And I think that's the important part. I mean, that's why we're here, right? We do all this work because rules matter. So I think I agree that the fee should be, even though, and just because no one's complaining doesn't make it right. Well, right may not be the right word, but
Yes, and as I recall, the Board of Engineers was generating a significant surplus because they have relatively few complaints compared to some other boards. So, Osterhaus.
Just a few comments. One, it is our practice that if we uncover that we have taken a fee without the authority, either statutory or in rule, we do issue refunds, just as a general practice. I also want to make it clear that as an administrative function, it wouldn't be the board issuing the refunds. It is actually an OPLC function. We're doing it on their behalf, but it does make a difference, and it shouldn't interfere with their ability to draft rules going forward. And I'm not sure if the JELCAR is aware of this. I think Representative McGuire and I had a conversation one time. But when I came on board, essentially January of last year, one of the first things that I did was go out 3 years and identify every lapsed and lapsing a rule close to expiration. And now we do meetings twice a year. We do one in January, we do one in July to identify every rule that should expire. And the hopes is to get out in front of the boards and give them enough time to promulgate rules without them lapsing. I don't think that was happening before I came on board, but it's certainly happening now. So in the future, the goal is to have that number of expired rules reduced to zero. So we are being proactive about that, but it's a step we just started doing in the last 2 years, I would say.
All right. Other comments?
Madam
I-
Chair,
yes.
Director Morrell and I, we were just discussing, we don't think that you could put a demand, if you will, on the condition or additional condition that the OPLC refund the fees. But what you could do is you could postpone this one and have them report back. You would need a waiver. The deadline on it is September 19th, so a couple of days before the meeting. But that is an option. You could do that as well for this one. Or
Fine.
you could do an objection and give them time to respond as well.
All right, in that case, I'd like to move to object to the rule on the basis that it was
Second.
being enforced while expired. What's that? Yes, it's been seconded. And comments, questions? All in favor?
Aye.
Opposed?
No,
Okay, opposed by,
May I ask a clarifying question?
Yes.
We were actually looking at ENG 500 and 400.
no, just 400.
We were just at 400. All right, I'm sorry. I thought.
Yes, no,
Yeah,
no.
they just
did-
moved on,
we-
116
We
and 400.
approved 500, I believe.
I don't think you had a motion on that one yet.
To approve, 2023-44.
Is there a second?
I'll sec, oh, go ahead. Representative Higgins Phillips seconded before me.
Okay, good move. Any comments or questions on the ethical standards? Okay, those in favor?
aye.
Opposed? All right, so we've approved one, objected to one.
So the next item on the agenda is 2023-49 which has to do with the Board of Natural Scientists, and this has to do with ethical standards. And just like 2023-44, these rules, the only issue is that they expired. These rules expired back on March 11th, 2019. And I apologize, my comment says March 18th. It's actually March 11th. And likewise, Ms. Tina Kelly did file a memo with regard to the enforcement of these rules, stating that no disciplinary action has been taken against, she put professional engineer, but it should be professional natural scientist, for violations to the expired Soil 500 ethical standards and voluntary certificate surrender rules. I also want to point out to the committee that there is a statute, RSA 31095, that does list a very limited amount of what you could consider ethical standards that are in the rules. So those could have been enforced under the statutory authority, but it seems as though they weren't enforcing any of these rules while they were expired.
Okay. Questions, comments? I believe you said there was something about the continued status that applied to these rules?
I believe it
Although-
was House Bill 655 that goes into effect October 3rd.
Uh-uh.
These rules would fall under those changes, just due to the statutory authority changing under HB 655.
Would that change the rule?
It wasn't the soil rules. It was the RAB.
Okay, thank you.
Yeah, that was my mistake. I did say soil. Douglas Osterhout, OPLC General Counsel, for the
Okay.
record.
So this rule will refer to the revised statute, but it shouldn't change the rule itself. Is that correct?
I didn't identify any issues with this. I'm sorry.
But after you pointed it out, I did go into
Oh, it
HB
is there.
655. It falls under there as well. It has
Okay.
the same issues as
It
the.
shouldn't change anything, though.
It really shouldn't, no.
All right, so fine, there were large portions of the statute that would just change the connections, so.
Yeah, it would just have to be the statutory authority changes to the new OPLC statute.
All right, well, that sounds like the first week in October, you'll be making some minor editorial corrections all over the place.
Move to
Question?
approve.
Second.
Second. Any questions, comments? All right, seeing none, those in favor?
Aye.
Opposed?
Next is 2023-50, which is the Real Estate Appraiser Board. Once again, these are ethical standard rules that have been expired. These ones have only been expired since February 2nd, 2023, excuse me. And likewise, there's also a memo to the same effect saying that there was no disciplinary action taken while these rules were expired. And this particular set of rules has more statutory authority, however, under RSA 310B18, A, specifically stating that the uniform standards of professional appraisal practice, ethical and professional conduct standards in effect at the time of the appraisal shall be the ethical and professional conduct standards to be followed at the time of the violation. So they did have the statutory authority should they have chosen to enforce, but it seems as though they just were not enforcing due to the rules being expired, which is also fine.
Or perhaps the real estate appraisers were behaving ethically, or as far as the board could tell.
One would hope.
Right. Questions, comments, motions?
Move to approve.
Second.
Okay.
Oh, and I apologize. This one did have a conditional approval filed. So does the motion,
Move to approve as amended.
thank you.
Okay.
Second.
Any further discussion? Those in favor?
Aye.
Opposed? All right. And more on the real estate appraisers.
Yes, the next one also has to do with the Real Estate Appraisal Board, 2023-61. This one is on continued statuses, and very similar to 116 for engineers. There was a conditional approval filed. However, these rules were previously expired. They've been expired since February 2nd of 2023. So there may be some questions about enforcement. And then additionally, there are fees in these rules because it's the renewal of these particular licenses. So there is a comment with regard to that informational note on the fees. But additionally for this one, I did want to point out that there is also a board rule, RAB 306.01, which also contains a fee schedule that includes a renewal fee. So that is a rule that will need to be repealed if they want to continue with the PLC fee so that there's no conflicting board rules.
Is that rule currently in effect?
It is,
Okay.
yes. So
So
that's
that-
why I wanted to bring it to the board's attention. It's currently in effect and therefore in conflict with the OPLC fee rule. Additionally, with this particular proposal, there is a comment with regard on page 1 of the conditional approval text regarding the license expiration period, which is something we have talked about before. The OPLC says every 2 years, but this particular board has a rule that says every 2 years on their birthday, whereas the OPLC's rules say every 2 years at the date of issuance. But I believe the OPLC has already addressed this issue that if it expires on your birthday, it'll just continue to expire on your birthday because that'll naturally be 2 years. But there's a unique certificate or registration with these rules with regard to appraisal management companies. There is a board statute that specifically says that the registration will expire every year from the date of issuance. However, these rules have it expiring every 2 years. And there is a little bit more of a unique situation, as in these are not licenses, so it's unclear of whether they'll fall under the OPLC's 310 A authority of renewing every 2 years for licenses, as this is just a registration for management companies, and it doesn't seem as there's any new legislation to address this specific issue.
Lovely.
And
Well, let's go. Is that all with that point?
for that point, I have a couple more comments on this
That's
rule as
fine.
well.
Mr. Asherhouse is panting at the bit to explain what he's doing about this.
I don't mean to look desperate. Douglas Osterhout, General Counsel for OPLC. I think our interpretation is that under 541A, license is defined in the state as any permission required by the state, and that does include registry. So I think our interpretation is that under the new language of 310, under 655, it would be captured and have that 2-year license period.
Okay, questions? Okay. Fine. Sounds like we ought to clean up the statute so it doesn't say something explicitly different, huh? Very good.
And then the final comments that I have on this rule have to do with the renewal form. There is a discrepancy between the printout of the form, as this form is done on the OPLC's portal, so there's no physical paper copy of the form, but they did provide printouts. But on page 1 of the amended text, it asks for the sponsoring provider, which is not something that's requested on the portal printout. I did talk to Tina Kelly regarding this discrepancy. She stated that they would be working with the IT department to put that on once the rule was approved and then became effective, which would be fine. However, this particular requirement, the sponsoring provider, was in the previous rules as well. So it's unclear whether there was a discrepancy at that time as well. As the rules are now expired, that's not an ongoing issue, but something that certainly should be fixed. Additionally, on the printouts, there's nowhere to put an electronic signature. It seems as though once you submit the application, that is essentially your signature, and therefore you're certifying that the application was submitted to the best of your knowledge, the normal language. However, this particular certification statement also states that by submitting this application, they are swearing under the penalty of perjury, which is, first off, not in the rule text, so that's a discrepancy, but additionally, it's unclear if the board has the statutory authority to have the applicant certify under the penalties of perjury. It's not explicitly stated in any of their statutes that they can require that, or that any sort of information provided would be subjected to that. It really should be under RSA 641.3, which is unsworn statements, which would be allowable under the statute and the rules.
Sounds like the people writing the forms are sloppy in their language in areas where they shouldn't be. Yes.
Douglas Suchet, General Counsel, OPLC. I think the issue is more complicated than I was led to believe, and I missed that. So, but it is true that we were waiting because in order to make those form changes, that's an IT requirement. It does take about 4 weeks to make those modifications, and we would make those modifications upon approval. So I just want to confirm that's true. Would that be an editorial change if we were to change the statute to 641.3, and could we agree to do that, or do you think it's more substantive? I ask.
I think that would be more substantive, especially because even if you were to cite to 641.3, you would need that in the rule text. It's not in the rule text anywhere, so that's a discrepancy. And because it's outside of the best of my knowledge and belief, it has to be in the rule text. So I would argue that that's not really editorial. It would be substantive, but we could certainly do an oral amendment to the conditional approval to say that that's a change that will be added to the rule text, and then you could fix it on the website.
Senator Gray?
If
From the discussion that I'm hearing, it sounds like this one is another one either to continue or object to. Because, when you say, change, and you say it's more substantive than that, further discussion needs to go on. What's the preference to either object or to continue?
So certainly you could object to these rules based on that, but also just like 116, this has that fee where the fee discrepancies that was talked about in the engineers 116, which you had previously objected to on those grounds. So if that's the course the committee wants to take, they could certainly add that change as something that needs to happen in the preliminary objection response.
So moved.
Second. Any discussion? Call questions, comments? Yeah.
And the final,
So we need to take a vote on this.
Oh,
Is there-
sorry,
is there any, are there any more issues that we need to discuss before we vote on the objection?
no, that was all for this
Okay.
proposal.
In that case, just questions or comments on the objection? Those in favor?
Aye.
Opposed? All right, and the objection response can address all of these issues. All right, moving on to the Mechanical Licensing Board.
So this particular proposal, there was an amended conditional approval filed. This one has an informational note to the committee at the top of page 1, just to inform the committee and also as a reminder to the board. This board was moved from the Department of Safety over to the OPLC within the last year or so, and therefore their abbreviation for their rules is being changed from SAF MEC to just MEC. This particular proposal only has various sections of 300. It's not the entire chapter. So when the board goes to certify the rules, should they be approved and adopted, when they certify, they need to go through the entire chapter, the entire 300s, to change that on every single rule. That is something that can be done editorially, but it is something that really needs to be done. Additionally, on this proposal on page 5 of the conditional approval text, there's an unclear comment regarding the requirement or one of the criteria that the board takes into consideration of whether to grant a license to an applicant, and that is to determine if the applicant was mentally or physically competent to practice. However, the form doesn't have a lot of questions regarding the physical or mental ability to practice that particular profession, so it's really unclear how the board is going to make this determination with the lack of information. And additionally, this was a comment that was made on the conditional approval request that was before the board back in 2015. At that time, the committee did approve the rule as written. However, this is still an issue, and if the committee has any questions or wants that addressed at this time, they can still do that. And then finally, there is on pages 4 and 20 of the amended conditional approval text, that informational note regarding the fees, as there is fees cited in this proposal.
Okay. Well, questions, comments? I'm wondering how they check physical or mental capability from a form, particularly an online form where you can't see the shaky handwriting. Do you have any information on how the board implements that?
I've never actually seen it happen. Douglas Osterhout, OPLC General Counsel, so I'm not sure how the board would check on that. I think it is intended to be a little bit more flexibility, giving something that should happen during a licensing term. The individual is struck by mental illness or some physical handicap of some sort. I don't know the correct term, but I haven't seen it happen.
Director Morrell?
I certainly do not disagree with your concern, but I think this language has been fairly standard in various boards for a long time. What their process is, I have no idea. Maybe it's something that needs to be looked at to be updated.
Yeah.
With these kind of things, the board has other information, on continuing applications, that they can look at, complaints, et cetera, et cetera. So it sounds to me like this one is a legislative fix that the OPLC ought to come to us with something that talks about their criteria, and not necessarily try to cram it into something that we would do today. So that's my opinion. So.
And I also just want to say that should this had been a renewal, perhaps there have been other things to look at, but just to be clear, this is for the initial licensing. So once again, it's unclear how they would gather that information for an applicant who's applying for the first time and hasn't been under the board's jurisdiction before.
Mechanical Licensing Board, most of those people are apprentices before they get the full-fledged license. So the apprentice supervisor's reports or complaints for their work as an apprentice might be applicable.
And-
Senator?
And again, because there are complications, that's why it should be some kind of a legislative fix that the board comes to us or OPLC comes to us and gives us some kind of guidance that we can put into rule next revision.
Okay. What, other questions, comments? Representative Baroda?
No, no question.
Okay. Anyone else? Do we have a motion?
Move to approve.
Could we add that the OPLC come back to us with information on that part of the application?
That certainly could be a recommendation.
A recommendation, okay. Would that be agreeable, Senator?
As amended.
Okay, I'll second then. Anyone, any further discussion, comments, questions? Those in favor?
Aye.
Opposed? All right. Thank you. That completes our agenda. We will meet again on September 21st for the regular meeting, correct?
Yes.
Okay.
Just an additional piece of information. There were two bills that affected 541A directly this session, 358 and 266. I'm in the process of doing a memo to all the agencies to make them aware, and I will send copies to the committee members.
Thank you.
Yes, both House bills.
Okay. Any
And-
other questions?
Just an apology to the board for being late. There were two accidents on Route 4 and one in Rochester, and a school bus driver that didn't know that you're supposed to let traffic pass after you build up. And I think I was 14th or 15th in line, so my apologies to the board for being tardy.
Okay. No trouble. In that case, we are adjourned and we'll see you on the 21st.